numéro 15 du Comité permanent.
Welcome to meeting 15 of the Standing Committee on Fisheries and Oceans.
The territory of the Algonquin and Anishinaabe people, and express gratitude that we're able to do the important work of this committee on lands they've stewarded since time immemorial. Pursuant to Standing Order 1082, the committee is meeting to continue its study on the review of the Fisheries Act. La réunion d'aujourd'hui se déroule.
Today's meeting is taking place in a hybrid format in accordance with standing orders. Members may participate in person or through the Zoom application.
That all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to prevent audio and feedback incidents and to protect the health and safety of all participants, but particularly the interpreters. You'll also notice a QR code on the card which links to a short awareness video. I would like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. En ce qui concerne l'interprétation.
Regarding the interpretation,
Sur Zoom, vous avez
for those who are on Zoom, you have a choice at the bottom of your screen to choose between floor, English, or French. For those who are in the room, you may use the headset and choose the desired channel.
Through the chair. Pour les députés présents dans la salle, si vous souhaitez prendre.
Members who are in the room, if you wish to speak, please raise your hand. For those members on Zoom, and we have a lot this morning, please use the raise hand function. The clerk and myself will do our best to maintain the speaking order, and we thank you for your patience.
We have Shannon O'Connor, Deputy Director, Public Prosecutions, and Emma Beauchamp, Director and General Counsel, both from the Public Prosecution Service of Canada. And we have Hannah Rogers, the Director General, Environment Enforcement from the Department of the Environment. So with that, we are going to start with opening statements of the witnesses for 5 minutes or less, beginning with Ms. O'Connor.
Merci beaucoup et bonjour, Monsieur le Président.
Thank you very much, and good morning, Chair and honorable members of the committee. It is a pleasure for me to be here before you today to share information concerning the role of Canada's Services Department concerning offenses under the Fisheries Act and the regulations for its enforcement. And I wish to recognize, as Mr. Chair, that the territory where I'm speaking from is located on the unceded lands of the Algonquin and Anishinaabe Nation that have been here since time immemorial. I would like to begin by taking a few minutes to talk about the service I work for, which is an independent, national, responsible organization which has the purpose of enforcing federal laws. Under the Director of Public Prosecutions, operates under the General of Canada and can cause prosecutions and gives guidelines to Crown attorneys for how to conduct their prosecutions. We also have some 600 federal prosecutors and several hundred mandatories in the private sector. It has regional offices in all the major cities of Canada, as well as in the 3 territories. And it also includes in its ranks specialized prosecutors on economic and regulatory matters at the national level that conduct prosecutions under more than 75 acts and regulations dealing with regulations and economic crime, in particular, the Fisheries Act. The prosecutors do prosecutions and also provide advice and provide support to regulatory organizations through initiatives of training and bilateral meetings. The attorneys also provide advice on regulatory matters at the investigation stage, which provides support during trials as well. And this facilitates dialogue and contributes to improving the conduct of investigations and prosecutions.
To the safety and security of Canadians. They play a key role in the criminal justice system by serving a truth-seeking function in criminal proceedings, as the role of the prosecutor is not to seek a conviction at all costs. At the same time, Crown Counsel must be strong and effective advocates. Our role is to effectively lay before a trier of fact credible evidence relevant to an alleged offense, firmly and to its legitimate strength, but also fairly. Prosecutors act independently in conducting prosecutions and advising investigative agencies. This independence ensures that justice is impartial and that cases are handled based on facts without improper interference. In conducting prosecutions, PPSC prosecutors are guided by the rules and guidelines in our PPSC desk book, which is publicly available. It sets out the principles which all federal prosecutors must follow in the exercise of their prosecutorial discretion. An important guideline in our desk book is Chapter 2.3 in respect to the decision to prosecute. This guideline was updated in 2023, prompted by an ongoing assessment of our policies that focused on providing clear guidance to prosecutors on how to be more proactive and conscious about recognizing bias, discrimination, and other factors that contribute to the overrepresentation in the criminal justice system. As set out in Guideline 2.3, to determine whether a prosecution should proceed, we ask ourselves whether there is a reasonable prospect of conviction and whether it is in the public interest to prosecute. This is our decision to prosecute test. If the charges do not satisfy both parts of this test at any point in time in the prosecution, the prosecutor will end the prosecution. Each file is always assessed individually based on the specific circumstances of the case. All persons charged with offenses, including Fisheries Act offenses, can expect the PPSC to conduct prosecutions in a manner that is equitable, objective, and independent. Thank you. Merci.
Thank you very much, Ms. O'Connor. And next, we're going to go to Hannah Rogers for 5 minutes or less.
Bonjour. Good morning. Good morning, Mr. Chair and committee members. My name is Hannah Rogers, and I've been the Director General of the Environmental Enforcement Directorate at Environment and Climate Change Canada for approximately 5 years. Je vous remercie de m'offrir l'occasion de...
I wish to thank you for giving me the opportunity to appear before the committee to discuss the Fisheries Act and the role of Environment and Climate Change Canada in this application. I would like to mention that I'm speaking to you from the traditional lands of the Algonquin National Nation. Every day, I'm reminded that our work to protect the fisheries and water resources supports our shared responsibility to be good stewards of the land, an important value long upheld by Indigenous peoples.
Role in enforcing the Fisheries Act. Our department is responsible for administering and enforcing the pollution prevention provisions of the Act. These provisions prohibit the release of substances that are deleterious to fish into water unless expressly authorized by regulation. This is one of Canada's most important legislative tools for safeguarding fisheries resources and protecting our waters from pollution. Its requirement applies broadly to all Canadian fisheries waters. ECCC created a separate branch, our enforcement branch, in 2005, following a standing committee report calling for an independent, centralized enforcement agency to ensure the independence of enforcement. Our mandate is both broad and complex. We operate in every province and territory with about 266 trained officers who enforce the laws and regulations across a wide range of industrial and other activities. This includes the enforcement of several regulations made under the Fisheries Act that authorize the release of deleterious substances, but under strict and highly controlled conditions. To date, 7 such regulations have been developed, including those for the metal and diamond mining sector, the pulp and paper sector, and municipal wastewater systems. Our enforcement officers conduct inspections to verify compliance with the Fisheries Act in accordance with the publicly available compliance and enforcement policy for the habitat protection and pollution prevention provisions of the Fisheries Act. This policy establishes the principles of fair, predictable, and consistent enforcement and outlines the full suite of available enforcement responses. It applies nationally to all officials exercising regulatory authority. If an officer has reasonable grounds to believe there has been an alleged violation, they may take a range of actions, including warnings, directions, and prosecutions, to bring parties into compliance on a case-by-case basis. Of course, ECCC enforcement officers cannot be everywhere at once. For this reason, our organization uses a risk-based approach to determine where to focus our enforcement efforts. This ensures that resources are directed to sectors and activities with the highest risk of non-compliance and the greatest potential to harm the environment or human health, while also supporting departmental priorities such as incident response and referrals. In the year 2024-2025, under the Fisheries Act, ECCC enforcement conducted 2,458 inspections, which led to 18 new investigations. An additional 47 investigations were carried over from previous years due to their complexity and scope. Officers issued 160 warning letters, 63 directions, and 4 files were recommended for prosecution during this period. There were 10 convictions under the Fisheries Act, resulting in approximately $14 million in penalties and fines. Of this amount, $13,930, almost all of it, was directed to the Environmental Damages Fund, which supports projects that benefit ecosystems and communities across Canada. ECC takes environmental protection very seriously and will act against polluters when appropriate. Our officers are resourceful and use all their tools available to address non-compliance. Over time, enforcement officers have noted various challenges that impact the effective enforcement of the Fisheries Act. We are modernizing our approach by equipping officers with new technologies such as satellite imagery, drones, and remote sensing. In addition, we are examining whether administrative monetary penalties recommended by stakeholders and by the 2019 Commissioner of the Environment and Sustainable Development's report on protecting fish from mining effluent could enhance our ability to address low and medium severity violations and increase overall efficiency. Thank you, Mr. Chair and members of the committee. I would be pleased to answer any questions today. Merci.
Thank you. Thank you very much, Ms. Rogers. That concludes our opening remarks. We're going to go into the first round of questioning, the 6-minute round, starting with Mr. Arnold.
Thank you, Mr. Chair, and thank the witnesses for being here. As you know, we're doing the review of the 2018-19 changes to the Fisheries Act. Ms. Beauchamp, could you provide to the committee in writing for every year since 2018, how many investigations have been referred to PPSC by DFO, and how many charges PPSC has approved for each referral from DFO?
Thank you, Mr. Chair. In terms of statistics, we can look into the statistics that are available. We don't have necessarily the same tracking mechanisms as DFO in terms of what files are referred to us, as well as the charges that are being laid. And statistics are not necessarily the most representative way of determining how we prosecute offenses that are referred to us. We apply a two-pronged test, as was mentioned by my colleague, Ms. O'Connor, when we determine whether or not charges should be approved based on reasonable prospect of conviction and the public interest.
Thank you. Our stakeholders, the people that come to us, would certainly like to know those numbers. It's very relevant to them. That's the reason I ask. So if you're able to provide the number of cases or investigations referred to your department and how many are actually approved.
We can certainly endeavor to do that. Thank you.
Thank you very much. Ms. Beauchamp, considering some of the evidence this committee received in recent weeks, it's very important that we understand how PPSC decides who to prosecute and who not to prosecute. The PPSC desk book that was mentioned in your opening remarks state that Crown Counsel must only proceed with prosecutions where two conditions are met. Number one, there is a reasonable prospect of conviction, and number two, the prosecution is in the public interest. Ms. Beauchamp, when PPSC does this type of assessment of charges relating to fish harvesting, does DFO come to PPSC with the charges already defined or recommended, or do DFO and PPSC have conversations about the circumstances and actions in question and what corresponding laws and regulations are, and then determine what charges are appropriate?
Thank you, Mr. President. PPSC and DFO have an ongoing dialogue during both the investigative stage and the prosecution stage. So in other words, DFO has an independent discretion with respect to how and what they are going to investigate. We provide investigatory assistance during the investigative stage, and certainly what the evidence sustains the appropriate charge is part of the ongoing dialogue. ultimately, whether or not to move forward with those charges is PPSC's independent discretion based on, as you just referenced, our two-prong test. But we have an ongoing and engaged dialogue with our enforcement partners as well as with ECCC.
Okay, so when determining the first factor for prosecution, whether there's reasonable prospect of conviction, I assume that PPSC must assess both the activities in question and the applicable laws and regulations. Is that a fair assumption?
Yes, I mean, it is one of the factors, or there are a considerable amount of factors that we will assess, the most important being whether or not we have available admissible evidence. But there are other factors that we will take into account at the reasonable prospect of conviction stage. Available defenses, charter application, possible charter applications. These are all factors that we will take into account when we are determining whether or not we have reasonable prospect of conviction.
Thank you. So for potential charges related to possible fisheries harvesting offenses, what laws and regulations would the PPSC measure the alleged offense against?
I'm sorry, I might not have understood your question correctly.
Go ahead. For potential charges related to possible fish harvesting offenses, what laws and regulations does PPSC measure the alleged offense with or against?
Well, generally, so thank you, Mr. President. Generally, the offense that we will be looking at will be provided for in the Fisheries Act or in its related regulations, and those are the offenses that we will be looking at when we're evaluating what charges should be laid when referred by DFO.
Okay, thank you. As you know, this committee is studying the 2019 changes to the Act. Are you aware that C-68 in 2019 established in the Fisheries Act a new definition of the word laws? It is in actually paragraph 2 and 3 of the current Act.
I'm not familiar with the new definition, but I would be happy to look at it.
Okay, the Fisheries Act definition of laws established in C-68 states that the word laws includes the bylaws made by Indigenous governing bodies. Has DFO or any other federal entity provided PPSC with all the laws of every Indigenous governing body with whom the Crown has finalized fisheries resources reconciliation agreements or other agreements related to fish harvesting?
They've not been provided directly, but if a recommendation was made to lay a charge with respect to an Indigenous bylaw, they would certainly provide us with the text of the bylaw.
So the fisheries officers, CNP staff, should be provided with the information that's in those laws and bylaws that are considered law?
I can't speak to what DFO officers receive or have available to them, unfortunately.
Thank you very much, Mr. Arnold. Next, we are going to go to Monsieur Cormier pour 6 minutes.
For 6 minutes. Thank you, Chair, and thank you to the witnesses for being with us today. Ms. Beauchamp or Ms. O'Connor, whoever can answer the question. For those listening, and even for some colleagues at the table, the field of law is sometimes complicated and technical, and it requires some explanation in order to understand how this whole prosecution process occurs. Could you give us a typical example, for example, of a group that is stopped under the Fisheries Act and then or arrested, and then after that the fisheries agents will decide to prosecute them? Could you explain how that process operates in order to have where it leads to a proper prosecution that would lead right to the courts?
Oui, absolument. Et merci.
Thank you, Chair. I'm going to begin.
M'aider aussi à donner l'explication qui, on espère, va vous aider le plus. Alors, c'est certain que chaque dossier, chaque situation est différente, mais généralement, après qu'il y a une enquête ou une agent, disons-nous, de DFO à une situation où ils pensent qu'une poursuite serait peut-être appropriée, ils vont nous parler généralement. Ils vont venir au bureau régional pour parler à un procureur responsable pour des poursuites réglementaires pour en discuter ce qui se passe. Dans les situations moins compliquées, plus régulières, peut-être pas beaucoup de discussions du tout. Dans une situation plus compliquée, des questions...
I'm sorry to interrupt. The chair is missing, but we're not getting translation.
Oh, I apologize. I'll hold on a moment.
No, that's okay. If we can stop the clock.
Okay, yeah, so we're going to briefly suspend for a minute while we figure this out here. What's going on here?
You have 6 minutes for your question. I don't see anybody in the room. Oh, here we go.
Monsieur Cormier, vous avez...
We're going to start the meeting over. We're going to start up again. Mr. Cormier, you have 6 minutes. So I was saying, Ms. O'Connor, just in order for us to understand how
avec des agents du MPO.
Prosecution begins when a DFO, somebody from DFO comes to see you. How do we get to these proceedings and to penalties later, or sometimes even imprisonment, I guess? How does this work? Thank you, Mr. Chair. The answer is that it depends on the situation. That the situation that's been discovered by the officers of the DFO officers. In a situation that is less serious, it could be an inquiry, and then the DFO officer lays a charge. It comes to us. We support the decision to prosecute. Is there public interest, and is there a reasonable chance of and then if that is the case, we go ahead. In situations that are more complex, we have a discussion, a dialogue. We have a fairly close relationship with all
avec le MPO,
the investigation organizations, but also, of course, with the DFO if there are questions. And if there's a situation where the opinion, where there's an opinion from the prosecutor, then we discuss that. We give our opinion so that they can make an independent decision in terms of what they're going to do. And when we look at the file, we go ahead with and look at to see if there's a reasonable possibility of conviction. Then we give the file to court. It usually takes a few months to go from the beginning to the end of this process. At the end, it's the issue of the sentence that comes into play if there was a guilty verdict.
Donc, Madame O'Connor,
So, Ms. O'Connor, in the last few years, these are topics that are always difficult to discuss. We don't want it to be out of context, but you've probably heard about recently a situation where there was illegal fisheries, commercial fisheries, First Nations fisheries, and recently illegal fisheries, especially by First Nations, has led to a lot of talk in the country and also in the fisheries industry. You said earlier that when a decision to prosecute is made, there are communications with officials from DFO, and we decide if you should prosecute. You look at the evidence, and
quand ça vient
in the case where
poursuite au niveau
it comes to prosecution with regards to First Nations, are there cases where
d'être plus clément, si je pourrais dire,
there may be more clemency?
avec la loi?
Or do they really apply the law?
On essaie.
Is the law really apply in a context where we try to exercise more caution, keeping in mind reconciliation, and knowing that if we stop a certain group, it could lead to a bad look, publicly speaking? Do you have these type of discussions when you speak with DFO, especially when a First Nation is concerned? Generally, yes. We have discussions about a lot of topics that involve our prosecution files. And when there are difficult situations in our communities, it's something that PPSC considers independently. So it's difficult. I understand that it's difficult to explain it as well, but there are factors. It's in paragraph 2.3 of our guide. So that tell us, okay, we're in a situation of public interest. Just give me a second. So that there might be a lot of damage caused to the community. So that is a factor that we take into account when we decide if we should go ahead. So damage, what do you mean? If you prosecute a certain group, it might cause tensions in a community? No, I mean, like in fisheries, I'm talking about the resources themselves. If there's a problem that involves these resources, then, and let's say we look at it as an environmental issue.
J'ai juste une minute de reste. Donc, comme vous avez dit tantôt, les agents.
When you said earlier that when the officials, MPO officials are involved, there's certain discretion. What do you mean discretion? Discretion to prosecute or to lay charges? Or what do you mean with discretionary power? Thank you, Mr. Chair. Discretion for for DFO officials and also for prosecutors. What I meant is that sometimes they lay charges without speaking with us, normally in less serious or less complex issues, or we encourage them to have a discussion before charges are laid. So to ensure that we can work together with our independent mandates. Thank you very much, Mr. Cormier. We're now going to go to Mr. Deschênes for 6 minutes. Actually, just a moment, please.
Okay, we're testing the English channel. This is the interpreter testing the English channel.
Languages to check our interpretation. We've had some connection issue here. So just want to make And clear on the French interpretation right now. It's good. Okay. Et prochainement en français. Est-ce qu'on...
And now, after that, can we hear the English translation now? Great.
Alors, maintenant, Mr.
Excellent. So now, Mr. Deschênes, you have the floor for 6 minutes.
Your mic is muted, Monsieur Deschênes.
I'm sorry. This is a mistake that often happens all too often. So hello, everyone, and thank you to the witnesses for being here. Ms. O'Connor, my questions are for you. The process I'm doing is to try to understand obstacles to enforcement of the Act as reported by people in the field. So I'm pleased that you're there so that we can talk about the rules that are applicable by the prosecutors to find out whether there are any charges laid. So I read the guide of the prosecution, Public Prosecution Service of Canada. I read part 3.3. I'd like to understand how it's interpreted on a daily basis. First of all, you have your director who has already explained things in August 2024 in a statement. Georges Dallaire said in the decision-making process, decide whether or not to lay charges, the prosecutors have to assess evidence and the public interest, take into account the impacts that systemic discrimination or racism could cause. So a brief question here. When your director talks about taking into account the impacts of systemic discrimination and racism, what does this involve? It has to be taken into account in a decision whether or not to lay charges? Thank you, Chair. In the second part of our question, is it in the public interest to lay charges? We consider factors that include over-representation of Indigenous people in the penal justice system, for example. But at the same time, in the guide, I don't want to contradict you, but what I note is that the issue of discrimination appears to apply in both stages. The first question that the prosecutors ask themselves is there a reasonable likelihood of obtaining a guilty verdict? And in the guide, there's what we can see as, for example, when the evidence against an accused is not very convincing and the personal situation of the accused includes mitigating circumstances, the prosecutor should consider not moving forward with the prosecution. And this is the case when the accused was a victim of systemic discrimination. And my question here is, isn't there a perception that would be reasonable on the part of any Crown attorney that all members of the First Nations are victims of systemic discrimination? Thank you, Chair. I'm pleased that you raised this question because it is a question that we discuss a lot at the PPSC. It's important to us when we consider factors in the history of Canada and the overrepresentation, and also ensuring that we prosecute in an independent manner and that does enforce Canada's laws. So this is something that we always discuss. But my question is, Ms. O'Connor, couldn't one conclude that all members of First Nations in Canada are victims in one way or another of systemic racism or discrimination? So I can speak on behalf of the PPSC and how we manage that issue. And we focus on the fact that the situations of an individual who is accused that come to us, that is an Indigenous person, the person could be impacted by discrimination and by racism. And we ask ourselves whether it applied in this case or in this file for a reasonable aspect of or reasonable prospect of conviction. You're quite right. It is a factor that we do, the biases, the racism, but also in a decision ultimately as to whether there is a reasonable prospect, but it's not very strong, and that is not necessarily in the public interest. Ms. O'Connor, well, let's talk about public interest. But first of all, for the prospect, the reasonable prospect, it seems reasonable to me for a prosecutor to say, since the person who would be accused is an Indigenous person, and because there's an issue of Indigenous residential schools and the whole history of the Indigenous people, that this would tend to block the authorization of prosecution, because I think that it's very hard to analyze things on a case-by-case basis as whether one individual Indigenous person is a victim. When we talk about systemic, it becomes difficult to apply, and I think it's very likely that the prosecutors will consider that most or all Indigenous people were victims of systemic discrimination. But I want to raise the second part of the analysis, the question of public interest. But now in the guide, and I would like you to explain to us how this could work out. But in the guide, it says that we have to, before we decide whether we lay charges, we go through the first stage. Let's say that there's a reasonable chance of conviction. Then we have to determine whether it's in the public interest, and we have to analyze the situation of the accused. And the guide states that factors that may influence the criteria of public interest are Indigenous identity. So the prosecutors must take into account the ongoing effect of colonialization, of Indigenous residential schools, and systemic
les accusés sont des membres des Premières
biases in the justice system when they're members of First Nations, Métis, and Inuit. So now we're in the question of public interest. And once again, what does this involve? This directive that's given to the prosecutors when they deal with a decision whether or not to lay charges against a member of the First Nations. A brief answer, if you please. We're at time now. So that is one factor. It's one factor that we consider. And in each case, we consider it in the individual circumstances of the accused and the circumstances of the allegations. So it's always something that is on an individual basis. The case that we consider it case by case, on a case-by-case basis. Thank you, Chair. Thank you, Mr. Deschênes. And the next one will be
round of questioning, starting with Mr. Dawson for 5 minutes.
Okay. I'm going to start. Thank you, Mr. Chair. I'd like to take a moment to thank Mr. Rogers for being here today. What are the most common types of Fisheries Act violations that we have identified in Atlantic Canada? Has there been any change in the trends for the violations over the last 5 years?
Thank you for the question. So in general, I can't give you specific statistics at this moment. I'd be happy to get back to you with more detail. We generally take action related to the 36.3 provisions of the Fisheries Act, which is deleterious when there are deleterious substances added to water where there's fish-bearing water or the prospect of it going into fish-bearing water. So a number of our cases are related to the general prohibition. There are also 7 regulations, as I said, under the Fisheries Act, and so a fair number of those in Atlantic Canada would likely be related to water and the wastewater regulations, and as well pulp and paper regulations. I can't tell you whether I have seen a major change over the last 5 years. I'd want to go back through our statistics to be able to identify whether there are trends. But again, we can get that for you.
Thank you. Are there any specific internal mechanisms that exist in your department in order to ensure consistency in the enforcement decisions across the various regions of your department?
Absolutely. Thank you for the question. Yes, one of our major principles is consistency. We follow the compliance and enforcement policy. Our officers follow that. We also do have a database that we use on a regular basis to analyze how things are being completed. If we notice that there's something that is potentially happening more in a particular region and less in another region, we address that immediately. We have 5 regional directors across the country who are responsible for their enforcement teams, and we meet regularly to talk about consistency to make sure we are doing things consistently across all of our regions.
Thank you. Are any of the cases you've identified common along New Brunswick's coast, especially along the Gulf of St. Lawrence and the Bay of Fundy?
I would have to get back to you on that. Maybe I can ask for a little clarification about that. Common law?
Common along the New Brunswick coast.
Oh, common. Thank you. I will get back to you whether we can give you specifics about the coast of New Brunswick.
Okay. How does your department ensure the accuracy and completeness of publicly reported enforcement data, such as the annual enforcement summary and enforcement notifications?
Thank you for the question. Yes, we have a database where we maintain statistics on actions that enforcement officers take. And every year we go through, we have a team of data scientists as well as other analysts that make sure that that data is accurate. If there are any concerns, they reach out directly to our officers to make sure those are complete and correct.
Does the ECCC track long-term environmental outcomes associated with enforcement actions, such as improvements in water quality and habitat recovery?
That is also a very good question. So I represent the enforcement side of things. We definitely work with our colleagues across the rest of the department who are responsible for things like monitoring and cumulative effects. So what we can tell you is potentially whether there's a level of recidivism. What we're not the experts in is whether the actual the environment has specifically changed, but my colleagues in other parts of the department can answer that question.
How does your department assess risk to sensitivity habitats in Atlantic Canada, such as estuaries, eelgrass beds, and salmon rivers, when planning enforcement activities?
So again, thank you for the question. Most of the actual scientific analysis is done by other parts of the department. So there are biologists and other experts in the department. We certainly work with them. We do look at what the greatest risk to the environment and human health is when we make our enforcement decisions. So we have done a number of studies, threat risk assessments, and analysis, again with our data scientists, to determine what substances, what regulations and laws are going to, where we should enforce to make sure we have the greatest impact.
How much time is left?
30 seconds.
I'll go to the next round after.
Absolutely. Thank you very much, Mr. Dawson. Next, we are going to go to Mr. Clausen for 5 minutes.
Thank you very much, Mr. Chair, and thanks to the witnesses for being here today. To Ms. Rogers, I'm just wondering about in the Fisheries Act, do you think that the penalties that are in there are justified, or should they be changed at all?
Thank you for the question. So I understand the penalties were last changed in 2013. I cannot provide my opinion at this forum, but my understanding is that there will also be a process going forward to establish whether penalties and fines across various pieces of legislation are sufficient.
Okay, I think in your opening statements you talked about the amount of penalties that were handed out, and I'm just wondering, is there any kind of penalty where the person who has broken the law would be part of reconciliation or part of restoring whatever the impact has been of their breaking the law?
That's a very good question. Yes. So most of the fines and penalties that are collected as a result of prosecutions, as well as administrative monetary penalties under our other legislation, not the Fisheries Act, go to the Environmental Damages Fund, which is run by ECCC as well. It's a separate part of the department, and they provide basically money to communities to restore ecosystems and the impacts of pollution. It may not always go from the funds from one particular infraction may not actually always go to exactly the ecosystem that was harmed. Sometimes they do, but they do all go to almost all go to restoration projects and community projects.
Can you give us an example or two of restoration projects that have been the monies have been used for?
I will give you one example where I believe some funds have been provided to the Ktunaxa people in the Elk Valley of British Columbia related to some prosecutions that took place there. I could get back to you with my colleagues from the Environmental Damages Fund to give you more specific examples.
Okay, and lastly to you, do you know of or could you recommend any parts of the Fisheries Act that could strengthen your enforcement?
Well, again, my role isn't to make recommendations on legislation. I'm the one that gets to go out and enforce things. As I did say, we have been looking at whether there's a possibility of using administrative monetary penalties, they are not prosecutions. So right now, under the Fisheries Act, we can issue a warning letter, which says don't do this again. We can issue directions, but those are only in cases where there's something that's actually occurring at the moment or is very likely to occur. So if there's a spill that's happening or about to happen, we can issue ministerial orders and then we can prosecute. There's no in-between for when there's a small or like a low or medium offense that's going on. So administrative monetary penalties, or AMPs, are something that we are looking at. But again, I don't want to get out ahead of anybody and say that that's a recommendation.
Okay, thank you. And to Ms. O'Connor, you talked about discretion in enforcement. Are there any laws that are not enforceable, for example, to First Nations communities?
Thank you, Mr. Chair. I'm not able to speak to what an enforcement agency might do or assess for themselves. What I can speak to is that if there were a question, the Public Prosecution Service would be available to provide advice to law enforcement agencies. There are none, however, no federal laws that I'm aware of where that is an issue subject to, let's say, a constitutional challenge alleging that the law itself is unconstitutional.
Okay, thank you very much. Sorry, I did have a question here. Are there unique challenges to Ms. O'Connor? Are there unique challenges with respect to gathering admissible evidence for Fisheries Act offenses?
Thank you, Mr. Chair. There can be challenges in the context of complex prosecutions, not unique necessarily to Fisheries Act offenses as compared to other environmental or regulatory or economic or criminal offenses. But some of the general challenges that one might expect to see relate to charter challenges, so whether evidence has been gathered in a manner that is consistent with charter rights or infringes charter rights. There can also be some questions in a regulatory context about when enforcement is being conducted under an inspection hat rather than an enforcement hat, and that can impact the evidence that's gathered and the charter protections that may or may not apply. So that is something that we train our prosecutors on, our regulatory prosecutors, so that they're always mindful of this and able to give good advice to enforcement officers so that we can support them in staying on the right side of charter rights in those circumstances. Those are the two that I would highlight in particular. One that I will also mention, though, is that there can be, or there is a consideration of Section 35 rights that arise in the context of Indigenous individuals. So an Indigenous individual may, if charged with, let's say, a Fisheries Act offence, although certainly not exclusively to that, raise a defence that is, it's a charter right, an Aboriginal or treaty right. And in that context, we will also consider that in the context of our prosecutions.
Thank you.
Mr. Clausen, et prochainement, on va en ligne avec...
And now we'll go online with Mr. Deschênes for 2.5 minutes. Thank you, Chair. Ms. O'Connor, I would like to add a request for documents to that done by my colleague, the Conservative Party. How many investigation files there were and how many were approved since 2018. I would like to add the following request. What is the percentage of the investigation files that are submitted to your section, which ultimately are authorized as a general rule, not just in fisheries enforcement, but in general in enforcement of all federal laws and criminal code? And what is the percentage of files that are submitted that lead to prosecution under the Fisheries Act enforcement since 2018? Thank you, Chair. The request is noted. We will get back to you on that. Thank you. Now, let's continue the discussion. Earlier, we saw that in the criterion of public interest, Indigenous identity has to be taken into account. So for those listening to us, if there is a scenario where a white person and a member of the First Nations are both arrested with a female lobster prohibited under the Fisheries Act. So it's possible that the charges may be laid against the white fisher, but when the decision is to be made whether or not the Indigenous fisher will be prosecuted, then the prosecutor has to take into account identity of the accused and take into consideration the impact of colonialism and Indigenous residential schools and systemic discrimination And so, Ms. O'Connor, am I right to say that it's quite possible that given two individuals committing the same offense, it's possible that by reason of the identity of one of the two who is Indigenous, there will be no charges laid on the First Nations member?
La question, c'est une...
It is, well, in each case, we consider the circumstances of the alleged offense and the circumstances of the individual. In the circumstances of that case, it is an individual circumstances. There are a lot of factors taken into account in the circumstances of the accused. Yes, systemic discrimination and those factors are considered for Indigenous people and also for other communities that have been impacted, let's say, by racism or systemic discrimination. And we also consider a lot of factors, the age of the individual, whether they have other offenses on their record or if it's the first time. It is a factor among many factors considered for each individual that always have different circumstances from one to another. If I still have a moment, I thought my time was used up, Ms. O'Connor. So it is quite possible, the scenario that I just submitted, that two people in the same situation, but one is Indigenous and the other is not. The Indigenous person would not be prosecuted due to their history. We cannot say. It always depends on the individual circumstances of the allegations and the circumstances of the accused individual. What would prevent you from agreeing with me on that interpretation? The importance for prosecutors consider the factors of each individual case. This is something that I always did when I was a prosecutor. Well, I'm still an attorney, but when I was handling files, we always considered the individual circumstances of that accused and the community where we were and the circumstances of the allegations, of the individual allegations. Thank you very much, Mr. Deschênes. And next we'll go to Mr. Hardy. Welcome to the committee today for 5 minutes. Thank you, Chair. Thank you for being here today. You're all raising very interesting aspects. We've been hearing testimony that's quite exceptional on enforcement that seems to be uneven among witnesses, tolerance of commercial offenses, and almost an absence of prosecution. And people come and testify that it really doesn't make any sense because it affects nature and even the objectives of what we're doing here. I've looked at the guide, the PPSC 2014 and 2020 guides, and we're talking about identifying the person who may commit a crime. And in 2014, there was only one mention of First Nations or Indigenous people. And in the 2020 guide, there are more than 20 mentions. I could read one out. When an offense is committed by Indigenous groups or individuals in a commercial operation that is not ancestral, will that influence it? Will you take into account that it's an Indigenous person and whether or not it's commercial? Is there a favorable prejudice toward the First Nations there? Thank you for the question. There are never prejudices in what we do with our cases. We consider each case individually based on the factors as described in our guides and by jurisprudence. Okay, so we're talking about not opinions, but public interest here. Can you define what is public interest? And in that case, how we can separate public interest depending on the ethnic origin or the situation you mentioned a few moments ago. It depends on where they are in the territory. The public interest, where does public interest no longer apply depending on the territory or ethnic origin of the person committing an offense? Thank you, Chair. If I understand your question, public interest always applies because sometimes, well, often with our cases, it's really in the public interest to prosecute. What is the public interest? Well, it asks us to. Well, it's a circumstance that we truly ought to prosecute in the field of crime and in the criminal court? Or is it a situation that could be handled with other options, reconciliation, let's say for a young person who it's their first time? Sure, they did something that is a criminal offense, but it's not as serious. Do we really need to prosecute within our system of criminal justice, or could we have alternative options to handle the situation? So in this case, you're saying that the public interest involves seeking specific aspects that could exclude a person from having prosecution. Is that what I should understand? Not necessarily to exclude a person, but to understand that this is the type of case that warrants, whether it's the type of case that warrants prosecution. What I understand from the witnesses here, what they observe is that there's virtually no prosecution for a certain type of population. And then when it's their turn, they always get wrapped on their fingers. So this inequality is not in the public interest. If the majority of the people are not allowed and a minority of people have access to it without enforcement, then it's a systemic exception. Thank you, Chair. I understand that concern.
Ça nous présente.
And when this occurs, we discuss it with people, and I can share with you because it's in the public interest now in 2024. There was this concern that came up. There was a practice of not prosecuting against a group of people in particular. If I can just break you off for a second, you're saying that you have directive not to prosecute a particular group. No, there was a concern, an issue, a question came to us where someone said to us that they think it's happening, and we told them, no, that doesn't happen. And we did an internal investigation. We had an attorney, a general attorney, take a look at a number of cases to ensure that it was not being done. And it was concluded that that's not happening. We consider each case on an individual basis, and there are some cases where prosecutions occur against individuals in different people from different situations. Fine. So perhaps I could add to what my colleague requested. Do you have a percentage of prosecutions, or not proposed, but potential prosecutions that come up, and where for the same crime or the same type of offense, in the case of Indigenous, they don't go forward, but if it's a Canadian, they move forward? Is there a percentage where if a crime enters the system, but for the same whether or not do you have percentages? No, we do not keep those percentages. So there's no concept, there's no traceability of the offenses submitted and the decisions that you made according to the ethnic origin of the person.
Déjà passé le temps.
The time is already used up. However, I'd like to answer in English to be more clear.
And we don't have those statistics, but what I can point to is publicly available information that has confirmed that in recent years, the Public Prosecution Service of Canada has continued to prosecute against individuals pursuant to the Fisheries Act, against individuals of Indigenous ancestry and individuals not of Indigenous ancestry.
Merci beaucoup, Monsieur Hardy. And next, we're going to go to Mr. Morrissey for 5 minutes.
Thank you.
Chair, and I want to thank the witnesses who are with us today for providing very clear, informative answers. Having said that, I want to go back to Ms. O'Connor on the question from my colleague, Monsieur Deschênes. Very specifically, his question was specific. He referenced a female lobster. I'm going to be clear, an egg-bearing female lobster, which goes to the heart of the sustainability of the lobster fishery. If two individuals were found in possession of an egg-bearing female lobster, well, let's commonize, 25-year-old male, First Nations male, or a non-First Nations, no other issues. Would there be any difference in your advice to the prosecution? Because this speaks to the heart of the sustainability of the fishery, which the courts have upheld. The minister ultimately must enforce on that. So could you answer that question?
Yes, thank you, Mr. Chair. So there will always be differences because a decision will be made based on the individual
But I equalized
circumstances.
them, Ms. Connor. I equalized them. 25-year-old, no physical, no intellectual differences. Both the same. But the only difference, one would be First Nation and one would be a First Nations male of 25 years. The other would be a non-First Nation. They're both holding a lobster that is viewed as illegal.
And so in the circumstances there, we would consider the individual factors that are relevant to that accused. I appreciate here you're asking me to hypothesize in a situation where there's only one.
I'm asking you to give it based on this. What would be the advice given prosecution? Would you advise DFO personnel to proceed with charges?
So in there,
same in both cases?
my apologies, Mr. Chair. Thank you for the question. In those circumstances, that would also depend on what was going on environmentally in that situation. But if what I would say is we would consider in our public interest assessment, absolutely, the factors that applied to the individual accused that were before us. But of course, in the, let's say, reasonable prospective, actually, no, forgive me, in the public interest, we're also considering factors such as harm to the community, the impact on the environment. There's one factor in particular
But Ms. O'Connor, I'm going to bring you back to the fact that both individuals that I described are in possession of an egg-bearing female lobster, which underpins the future of the fishery. There's nothing to do with community. If an individual can be in possession of that and not have charges faced against them, it undermines the whole future of the fishery. So regardless if you're First Nation or commercial, you're impacting the future of that fishery that's sustained. Mm-hmm. I would expect prosecution to advise the department to apply the law equally.
We certainly consider the impact such as public confidence in a regulatory regime and the harm to a community, the harm to, let's say, for example, sustainable fishery.
The community being the overall commercial fishing community?
The Canadian community.
Okay. Thank you. You've come close to speaking to it. In your opening comment, you referenced to prosecute economic crime. One thing that's currently much in the news these days is the possession of lobsters that have been acquired by cash. There's a lot of discussion in the fishing community about cash purchases going into the fishery, which is again undermining the future of the fishery. Could you explain a bit broader on when you say to prosecute economic crime? Is that viewed an economic crime by somebody purchasing a product for cash and not registering that product? There's no trace of it? Because cash is legal, providing it's all documented.
Mm-hmm. Yes. And so generally speaking, in my opening statements, I was referring to, for example, tax evasion.
Well, you're evading taxes if you're not recording sales
yes.
and paying for it with cash that never finds its way to CRA.
Yes, of course. And so we will absolutely consider the economic impact, though, of other criminal behavior. And in circumstances where there are, as this example, there are taxes being evaded, or there are other indicators that may support a reasonable prospect of conviction as it relates to the offenses being alleged, we will consider those circumstances in the assessment of not both whether to prosecute and then how to prosecute, how to bring forward the evidence before the trier of fact to establish the crime that's being prosecuted.
Thank you very much, Mr. Morrissey. That completes our second round of questioning. We're going to start the third round of questioning online with Mr. Small for 5 minutes.
Thank you, Mr. Chair, and I'd like to welcome the witnesses today. The number one purpose of the Act is the conservation of fish stocks. So, how can effects or damages to communities or groups supersede that in prosecuting charges, Ms. O'Connor?
Thank you, Mr. Chair. And so when the factors that a prosecution service considers are different, not necessarily, they overlap, but they are different than the legislative purpose of any particular legislation. And so while legislation has its policy purpose, prosecutions as independent consider a variety of factors, including the policy and community considerations that have been put forward by our parliamentarians.
Has there ever been a time when a directive has been issued, say from the PMO to lean in a certain direction in terms of prosecutions?
Short answer to your question is no. The Director of Public Prosecutions Acts provides for the independence of the Public Prosecution Service, but also for a relationship with the Attorney General. And so it is possible, pursuant to sections 10 to 13 of our Act, for the Attorney General to issue a direction to the Public Prosecution Service of Canada, either generally or case-specific. Those must be gazetted. They must be made public so that the public is aware of such a direction. While there have been general principled directions issued by attorneys general in the past, there has not been a case-specific direction issued to the Public Prosecution Service of Canada.
So we've had some testimony about the owner-operator policy and fleet separation. Have you had any cases come across your desk as it relates to owner-operator, and that policy was strengthened in the 2019 Act? Have you had any at all come across your desk?
Mr. Chair, just one moment, please. Not personally familiar. If I may ask a clarifying question, is this in relation to inshore regulations?
Yes, it is.
Thank you. Thank you for your indulgence. We have certainly had conversations with DFO regarding inshore regulations and investigations. I'm not able to comment further on those, but I don't have more specific details of that.
So what factors would influence charges being laid under owner-operator?
Thank you, Mr. Chair. And so if there's a reasonable prospect of conviction that there's been a criminal act, violation of the law, and then, of course, if it's in the public interest to prosecute, then we would proceed with the prosecution.
When a Fisheries Act charge lands on a prosecutor's desk, does it contain information, a description of the individual that the charge was laid against?
Thank you, Mr. Chair. It may not. Certainly we'll be able to glean information about an accused individual. Oftentimes, and I would hazard to even say most oftentimes, prosecutors learn about the individual accused over the course of the prosecution. So prosecutions take months, sometimes years, and we will always invite information from defense, whether it's defense counsel or a self-represented accused, to share information. But there may not be a lot of details in an investigative file. The investigative file is generally focused on the alleged crime and the evidence that would be required to prove that.
So with respect to Atlantic Canada, is there a region or a province that has had more charges prosecuted than any other?
I don't have statistics on that, but I can indicate that where charges are brought to the PPSC, we are always responsive and engaging actively with investigative partners or investigative bodies, so that we understand the file and that we are able to bring it forward for prosecution.
Mr. Chair?
Is there That's we've elapsed the time there. So
Thank you.
next, we are going to go to Mr. Cormier for 5 minutes.
Merci. Madame O'Connor.
Thank you, Ms. O'Connor. You see that we've asked a lot of questions in terms of First Nations, in terms of fisheries, and certain incidents that took place over the years. And I think that it's our duty to do so. It's our duty because, as you said earlier, it's in the interest of Canadians to trust the justice system, regardless of the color of your skin, your ethnic origin. Canadians should be able to trust in a justice system that is fair, just, and that respects the laws that we have. Of course, I always say we're not going to imprison somebody who's a youth who goes to a little store and steals a chocolate bar. We're not going to sentence that person to several years in prison. But when an individual, if it goes from a chocolate bar to an armed robbery, that's a very different case. So in the case of fisheries, and that's what we're talking about today, what concerns me is to see,
Une exception.
I don't know if we should call this an exception in the way that you're wording it, but to see if for certain groups, we're going to go look at the person's background.
On semble avoir
we seem to have some degree of favoritism with certain groups. Do you think that it's linked to everything that has had to do with reconciliation? Reconciliation furthered by the government with Indigenous peoples, and this choice that we want to have a new vision, a new type of collaboration with these people. But in the end of the day, at the end of the day, if the laws are not applying, no matter what the cultural community is, don't you think that if we start to have choices such as these, that it will undermine Canadians' trust in the justice system? Thank you, Mr. Chair. I completely agree that it's essential for PPSC that they have the public's trust in the justice system. And we're grateful that you've invited us here to allow you to ask these questions. There is no favoritism whatsoever in the way that the PPSC makes its decisions. We make decisions given the individual circumstances of a file and of the individual, and we look at many factors for individuals, and also in terms of what has happened, the allegation of the crime. So as you've mentioned,
les antécédents, ouais.
Oui, les antécédents, merci.
As you've mentioned, someone's criminal record is very important. That's another one of the factors that we look at. It's also important for us, as I mentioned, that the public understand and that they trust the system, the justice system. And we understand that there are questions that are asked sometimes in terms of how we arrive at our decisions. When we can, we discuss it with victims, with communities, with investigation officers, and sometimes it's privileged information, so it can't be discussed. But there were media present about these topics in the Atlantic. And one thing that was mentioned is that there were at least 50 cases where there were prosecutions of Indigenous people.
Aussi avoir vos dossiers, vos enquêtes, ou même jusqu'à des poursuites qui a été jusqu'à la fin.
So the prosecutions up to now, what you've had under the Fisheries Act from 2006 to 2015, if you could provide the information on those cases, please. Ms. Rogers, I would just like to ask you a question on the Environmental Act. If a fisheries plant releases wastewater or chemicals into the bay or into the sea, is it under your responsibility or is it under provincial responsibility? If it is water that is spilled directly into the water, where fisheries can occur, then it's under our responsibility. Fine. So,
Dans cette optique-là,
in that sense,
province, même si délivre
even if the province delivers a plan license to the plant, are they the ones that would revoke the permit after your recommendations, or would you be the one doing it? Thank you for the question. Generally, if there is a provincial license, the province has responsibilities to verify that the
du permis sont.
regarding that the details of the license condition is respected. What about water testing? Would you be the one testing it, or would it be the province? I'm sorry, Mr. Cormier, but the time is used up. Thank you. We have 5 minutes now, but at this stage, we'll move on to Mr. Deschênes for 2.5 minutes. Thank you, Chair. Ms. O'Connor, you mentioned earlier that an investigation was done internally to determine whether certain groups were excluded from prosecution. So I would like to add that to the document request, please.
Yes. Si je peux me permettre, juste pour
If you will allow, in order to clarify the documents that are requested, you mentioned that an internal investigation had been conducted within the Prosecution Service of Canada as to whether groups were more subject to prosecution or not, and you said it was not the case, and I would like to see the report of that investigation. Thank you, Chair. Those files are not under it's not up to the Prosecution Service of Canada to share it. It's other individuals who shared that with the media and not ourselves. But it was an internal report within your service? Yes, but it's something which was prepared for our previous assistant director. Seeing it as it was a report produced by your service, whether there are media leaks, that's another matter, but I'd like to obtain it. I take note of your request. I will discuss it with our director. Thank you, Ms. O'Connor. I also understand your reluctance to answer the question I asked earlier, and Mr. Morrissey carried further, but I don't want you to think of the political impacts of it. I think your role here is to explain the rules and how things operate. And the feedback we get from the field is fisheries officers telling us confidentially that they have received directives to be more tolerant toward First Nations members and sometimes even not to step in. And sometimes they're told, well, it's too complicated. And the process is try to understand how all of this happens and what explains that situation. And when we look at your guide, and it's written in black and white, I don't think we can deny this. It's clear that Indigenous identity must be taken into consideration by a prosecutor. I just want you to confirm that. You don't deny that because it's really written in black and white in your guide. Prosecutors must take into account the ongoing impact of colonialism and the residential schools and overrepresentation and systemic discrimination in the justice system. They say that those factors can clarify certain aspects on the moral guilt of the accused and can lean towards not prosecuting, taking into account the relevant factors. So can we agree that in the current system, in fact, an Indigenous offender compared to a white offender, when all other facts are equal, there will be an additional stage in the thinking of the prosecutor as to whether, given all the past of the First Nations, whether we should avoid prosecuting.
Madame O'Connor.
We've reached the time, so Ms. O'Connor, if you could give an answer in writing to that, it would be appreciated.
Yeah, sorry, we're at time here, so we're going to have to move on. Next.
Oui, on est à court de temps. Maintenant, Monsieur Arnold, pendant 5 minutes.
Mr. Chair, and again, thank you for providing the clarity so far. But both Ms. O'Connor and Ms. Beauchamp, it's important that we as legislators understand how PPSC decides who to prosecute and who not to prosecute. You work independently for the prosecution of Canada's laws, is that correct?
Yes, that is correct.
Okay. In order to do your work effectively, I assume your work is guided by knowledge of Canada's laws. Is that correct?
Yes, all prosecutors study and are familiar with Canada's laws.
Okay, I believe that earlier you stated you're not necessarily privy to all bylaws and laws, and that they may be provided by DFO CNP staff at the time of your discussion over prosecution. Did I hear that correct, that you are not privy to all of the bylaws and laws?
Yes, in the sense that an individual may not be familiar with all the bylaws, but I think it's important also to understand the nature of the PPSC's jurisdiction, which is to prosecute federal offenses. And so our jurisdiction is to prosecute, for example, the Fisheries Act and the regulations associated with the Fisheries Act.
But if are there bylaws that permit certain actions that are not permitted within the Fisheries Act, how would that apply?
If the public prosecution does not have jurisdiction to prosecute those, they would not be brought to us for prosecution.
So DFO CMP staff may or may not have access to bylaws and laws that are deemed equivalent or sometimes superior to the Fisheries Act. Is that correct?
I'm not able to speak to what DFO officers will or will not have access to.
Okay, so how does PPSC determine if an alleged offense merits a charge if PSPC does not know the laws and regulations that could be applicable?
Oh, excuse me, I'm sorry. So if there are other, let's say, for example, bylaws that may be viewed in contravention or may be in contravention with the Fisheries Act or a regulation, we will certainly assess. That can be a very complicated legal question, but we will certainly assess the circumstances as it relates to the constitutionality of those laws, the primacy of which law would take into account. We would, where appropriate, work with Department of Justice colleagues to obtain their expertise in that area, because really the applicability of laws and the supremacy of laws is a question for the Department of Justice, and where that expertise would be required to inform information provided to us to inform how we exercise our prosecutorial discretion. That's a relationship we have and certainly avail ourselves of to ensure that we have the appropriate expertise on these very complicated legal questions.
So you would be provided with those bylaws and laws that are outside of the Fisheries Act?
Where there is a suggestion that that laws may not be, I use the term applicable very carefully, because that's a decision that would be made, for example, by a court. It's not for the Public Prosecution Service of Canada to decide which law is valid. We have partnerships, say, for example, again, with the Department of Justice, that allow for us to lean on their expertise and get the information that we need to make the appropriate decision.
That's interesting, because as democratically elected members of this committee, we've been denied access to agreements, bylaws, and so on that may be applicable in relation to fisheries activities. And yet they're out there and may be affecting how Canada's laws are applied. And yet we, as the legislators responsible for reviewing this Fisheries Act and providing any recommendations to any changes to the Act, are not aware of the bylaws and other laws that may be out there affecting the conservation of our fish stocks.
So I can't speak to the provision of information by different departments, and I certainly also don't want to be misinterpreted or suggest that we may be provided with information that's not otherwise available. I would have to know about specific instances of what information has been provided in specific cases.
Thank you very much, Mr. Arnold. Next, we're going to go to Mr. Connors online for 5 minutes.
Hi. Thank you very much for the witnesses coming out. Certainly an interesting discussion. Ms. O'Connor, you mentioned that there, I think, 75 acts and a number of regulations that you have to interpret when you're moving forward with some prosecution. Are there prosecutors that specialize in the Fishery Act today? Is there anyone that specializes, or is it a case-by-case process?
Thank you for the question, Mr. Chair. We do have regulatory and economic teams across the country, and those prosecutors will specialize in the prosecution of regulatory offenses. Some, where there are perhaps a higher volume of, say, for example, Fisheries Act cases, will develop absolutely an expertise and a specialty in those in that type of prosecution. And it is extreme. We have expertise centrally in our headquarters as well as regionally to ensure the highest quality standard of prosecutorial excellence when bringing forward these files.
Okay. I want to go back to, I think, was Mr. Small that mentioned conservation and sustainability is one of the key factors of the purposes of the Fisheries Act. And then Mr. Morrissey gave you an example of an identical situation. The only thing different would be First Nations. So I'm wondering, how would a violation under the Fisheries Act not be considered in the public's best interest to move forward with prosecution?
Thank you for the question. In considering the public interest in prosecuting, let's say, a violation of the Fisheries Act, we would consider a variety of factors that include the harm to the community. Say, for example, and there I'm saying community, but it could be the harm to the environment, the impact that alleged offense has had on the environment. Sometimes it is small, sometimes it is significant, and that plays a role in our assessment. And this is, of course, not to say that where it is small, a prosecution is not in the public interest. It is one of many factors that we take into consideration. We also consider whether the prosecution of an offense would maintain public confidence in the regulatory regime.
Okay, thank you. Are there times when the DFO officers would disagree with prosecutor or your department about moving forward with prosecution?
Yes, that does occur. And that is, we develop and we believe very strongly in the importance of an open dialogue. Because of the nature of our independence, investigative agencies, this case we'll say DFO, because that's what we're talking about, they may make decisions that we would not have made. That is their independent discretion to do so. And we may make decisions that they would not have made, and that's our independent discretion to do so. But when we do so, we ensure that we have conversations and dialogue to understand each other's perspectives, and we take that into consideration in our decision making. And we will also discuss afterwards those decisions, and we would do the same, for example, with my colleague, to ensure that we have an open dialogue and a collaborative relationship appropriately within our independent spheres.
But the ultimate decision would come down to your department to make the final decision if it would move forward.
To continue a prosecution, yeah, or to proceed with or continue a prosecution, yes.
From your, say, department's perspective, or your are there aspects of the Fisheries Act that are redundant and may cause you to not move forward, or may cause delays in your ability to act? Do you identify or see anything that might need to be changed in the Act in order to get convictions?
To the Public Prosecution Service, we are available to, whether it's departments or committees, information about the prosecutorial impact of particular legislation that's being considered for amendment or new legislation. It is not for us to usurp the role of our parliamentarians in making decisions, policy decisions about how acts should be changed. But if those are being contemplated, we are available to answer questions about what the impact on prosecutions may be of those particular amendments. Absolutely.
Would it be your role to make recommendations to something where you see something that is not working in the Act or that is redundant in the Act in order to be able to, so that would help us make better decisions?
Part of the importance of our independence is that we not overstep into the policy lane of the Government of Canada, and that we keep on the prosecutorial side. But certainly we can share with our colleagues at departments about, for example, how an amendment might impact a prosecution, making it either easier or more difficult, for example, to tender evidence or establish an offence beyond a reasonable doubt.
Mr. Connors. Next, we're going to, that finishes the third round. We're starting the fourth round here with Mr. Arnold.
Thank you, Chair. I'll use a minute or two here, and then I'll pass it on to my colleague, Mr. Hardy. Ms. O'Connor, I want to go back to the questioning on how the bylaws and laws, or how other laws and bylaws may impact enforcement and prosecution of the Fisheries Act. How does PPSC determine if an alleged offence merits a charge if the PPSC does not know all of the laws and regulations that could be applicable?
So the PPSC is absolutely familiar with all of the federal laws and regulations that we have jurisdiction to prosecute. If there is, say, for example, a bylaw pursuant to the Indian Act that may be viewed as in conflict, we would be sure to consult with constitutional experts to determine.
What about other laws and bylaws that are outside of Canadian or parliamentary legislation?
Yeah. So if it's just to clarify, it's a prosecution pursuant, let's say, to the Fisheries Act, a federal law, and there isn't another law that is in conflict with that? Yes. Or is it to prosecute other laws?
No, or both.
So in terms of the prosecution of other laws, that is likely not our role. It may be, for example, the Provincial Prosecution Service. Where it is ours, it is not, so I should say, it is not the public prosecution's responsibility, role to determine the validity of a law. That would be brought before a judge. And so in circumstances where there's a question on the impact of arguably contradictory laws, one avenue, probably a very common avenue to resolve that, would be to bring the file, prosecute the file, for example. And if defense raised that before the judge as a defense, we would bring forward the prosecution aspect, the defense would bring forward the defense aspect, and a judge would rule.
Okay, so how do we as legislators solve the conundrum that we as legislators don't have access to those other laws, bylaws and laws?
I can appreciate the frustration. It's unfortunately not for the PPSC as an independent prosecutorial authority to provide advice or solutions in that circumstance.
Okay, thank you. I'll pass my time to Mr. Hardy.
Merci beaucoup. Alors, je veux juste revenir à ce que vous avez dit tantôt.
Thank you very much. I'd like to come back to what you said earlier. There is no favoritism when you make decisions. I find that interesting because from 2014 to 2020, the former act that was in, there was no concept of the First Nations, or one mention of it, rather. Yeah, starting from 2020, because of an overrepresentation, as you said earlier, there were some 20 mentions in the guide. And how can you, with those new concepts raised, with the idea of bringing down the representation of First Nations in the number of arrests and so forth, but not have any, how can you not have any data as to how many cases work their way all the way through the system or not? When you have 20 times the number of mentions of First Nations, how can you say if there's no impact? We measure the circumstances of each individual case. For us, success is really to carry through a case when our decision to prosecute, when we fulfill it. But the initial notion was to bring down First Nations representation in the number of arrests and prosecutions. That's the intent of having brought in those aspects in the guide. The intent is to ensure that our prosecutors consider that factor in their decision that they take regarding the circumstances of a case. So the goal is to consider that, to bring down the representation. So we cannot say that there's any favorable prejudice or favoritism to First Nations if you include in the equation something that's going to make a distinction between a Quebecer or a Canadian or a member of the First Nations. Do we agree on that? With all due respect, no, there's no favoritism in our decisions, and the PPSC takes actions in our role and responsibilities within the justice system. The penal justice system. We try to contribute by not contributing to overrepresentation of Indigenous people in the criminal justice system. We are a part of that situation. Okay. I don't have time with 10 seconds. Thank you very much, Mr. Hardy. And the next.
For 5 minutes.
Thank you, Chair. Question to Ms. Rogers. Ms. Rogers, you referenced roughly $14 million in fines under environmental infractions, correct?
Under the Fisheries Act, yes.
Under the Fishery, okay, the charges are under the Fishery Act, but as related to environmental infractions?
So we enforce both the Fisheries Act, the Canadian Environmental Protection Act, as well as other legislation. So we have, I don't have the fines specifically under all of our, the amounts for under each one, but
these were for environmental infractions, not fishery infractions.
Yes,
okay.
Not habitat or fisheries, commercial fisheries.
Often you'll hear that the courts will lay a charge and impose a fine, but then nobody pays it. So in this case, are those fines, are they realized upon?
Yes, these are as a result of prosecution, so they are collected.
You're sure of that?
I would have to go back and confirm that every single penny was collected.
Well, I don't have to be to the penny,
but in general, we do not have concerns about the fines from prosecutions being collected.
Because on the fishery side, that's not the case. Often the fine will be imposed by the courts, and it's laissez-faire whether it's collected or not. So thank you on that. Ms. O'Connor, who makes the final decision on proceeding with charges? Even if the public prosecution branch was advised maybe not to, who makes the final decision?
Thank you, Mr. Chair. It depends. It depends on the jurisdiction. We have some jurisdictions in Canada that are called pre-charge approval jurisdictions where police forces and regulatory enforcement, they come to us before charges are laid and we approve them or not, applying our decision to prosecute test. That's the minority of jurisdictions, really 3, and some have some areas within their jurisdictions. The majority are not pre-charge approval jurisdictions, and therefore the police or enforcement agencies can lay charges and often do lay charges before consulting.
But specific to DFO, charges being laid by DFO under the Fishery Act.
And so the same applies. In some jurisdictions, it is us in the sense of a pre-charge approval, and others, for example, Nova Scotia is not a pre-charge approval jurisdiction. So DFO officers can and do lay charges, and the file is then brought to the PPSC.
So are you leading me to believe then in some jurisdictions the provincial jurisdiction would override DFO's ability to lay charges?
No, and I apologize if I was unclear. What I meant is that the pre-charge jurisdiction, a DFO officer, let's say, would come to us. They would come to the prosecution service that has jurisdiction to prosecute that particular offense. For Fisheries Act offenses, it is the Public Prosecution Service of Canada across the country.
Okay. So the decision is solely between public prosecution and DFO?
Yes, yes.
Who makes the final decision? Okay, thank you. Just again, you referenced earlier, and you referenced no case-specific direction from any elected official.
Specifically, the Attorney General, who is the
well, this holds a different capacity when he assumes that, or she assumes that office.
Yes.
But it was because, and you referenced that if there was direction given on a policy side, it must be public.
Yes, any direction provided by the Attorney General.
And that's the only way from an elected official that direction could be given in any case.
That is correct. That is one of the, excuse me, I'm sorry, I didn't mean to interrupt you.
No, that's fine.
That is one of the important pieces of the prosecutorial independence.
Because often we'll hear, gossip on the street that charge was dropped because somebody talked to somebody and go. From your experience and in testimony to this committee, that does not exist.
That does not exist, no, and there's no power for anyone other than the Attorney General to direct the prosecution service on how to bring forward a prosecution.
Okay, thank you, Chair. Let's conclude my questions.
Okay, thank you very much, Mr. Morrissey. Et prochainement, on va à Monsieur Deschênes pour 2 minutes.
And next, Monsieur Deschênes, 2.5 minutes. Thank you, Chair. Ms. O'Connor, earlier, I gave you a long preamble and I didn't give you time to answer. I'll give you time to answer and perhaps clarify my question.
En vertu
Under your directives,
autochtone
is indigenous identity of a suspect
milité
something that can lean toward not bringing charges under the Fisheries Act?
Ça dépend des circonstances.
It depends on the circumstances. Yes or no? Is indigenous identity a factor that may lean toward not laying charges?
Les droits d'un individu autochtone.
The rights of an indigenous individual can be something that we consider, as I explained before, under Section 35 of the Constitution for the right of self-determination. Yes, but Ms. O'Connor, I don't understand why you don't want to voice your agreement with me if it's difficult. If I read your guide, it mentions indigenous identity. It says that these factors may clarify aspects of the moral guilt of the accused and lean toward not prosecuting in view of all the relevant factors. And that is the indigenous identity part in the guide. So I'm asking my question again. Is indigenous identity of a suspect something that can lean towards not laying charges under the Fisheries Act? It depends on the circumstances.
Ça dépend des
So it depends on the circumstances. That's an odd answer because your guide tells you that you must take into account this, which can cause charges not to be laid. But you don't read the guide the same way I do. Thank you for the question. I would just like to make sure that I'm clear. I will answer in English.
Even accused is one factor that we will consider. It is not an overwhelming factor, and the role that it plays, while always important, the weight that it will be given also depends on the facts and the circumstances of, let's say, for example, the alleged offense. There's some helpful Supreme Court of Canada legislation. I believe the case is Wells, which followed the Gladue case of approximately 20 years ago, that helps inform how those factors are considered. That factor is considered.
Il y a la règle Gladue aussi, mais la question c'est est-ce que ça peut...
There's also the Gladue decision, but can it lean? I don't say it does in all cases, but can indigenous identity lean it toward not laying charges? It is one among other factors that could lean.
Monsieur Deschênes.
Thank you, Mr. Deschênes. And next, Mr. Hardy for 5 minutes.
On se parle beaucoup aujourd'hui.
Thank you very much. We've been talking a lot today. Who makes the guide? I have a question for you. The guide is done by some attorneys that have a lot of experience, but ultimately it's our director of criminal prosecution or penal prosecution who gives the approval. Who suggested a change from 2014 to 2020 to include 20 times as many mentions of indigenous communities in it? The ultimate decision was up to the director of penal prosecution, both in the chapters. There seems to be a close link between the government policy and what was included in the guide during periods of between 2015 and now. Is there political influence on enforcement of the law? Is there political influence on the guide? No, absolutely not. There's no political influence, so there's no connection. You can guarantee that there's no formal or informal political directive that influences your work. Now, once again, I will speak English just to be sure that I'm clear.
In the Public Prosecution Services desk book or in the guidelines issued by the Director of Public Prosecution, the Public Prosecution Service absolutely considers public safety, concerns of Canadians, a variety of other factors when establishing, applying, and revising its policies. And so we consider the communities that we live in and the communities that we prosecute for. We do not take political direction. There's not political influence in how we, or how the director advises and guides and directs prosecutors.
Donc, ça serait une coïncidence finalement.
So it would be a coincidence then that both on the political side and on the side of the prosecution,
Qu'il y a eu
that there is an alignment towards
favoritisme, je pourrais dire.
favoritism, so to speak. I'm not the one saying it here. I've been told, the witnesses have said that it's 100% political. I have other witnesses that I could find here who tell us that they let things go, that there are no fines and no consequences that apply. So that's the perception of people in the field who tell us that they feel underprivileged. They feel that
L'ensemble de la population.
there is work that applies to the entire population, but people in the field, they're saying there's no favoritism. But do you have the impression that this perception of public opinion, that people should change their opinion? Do you think that we need to take action when Canadians and Quebecers are starting to say, hey, it doesn't make any sense? The advantage compared to us, we always get wrapped on our fingers. Is it the responsibility of your office to make sure that equality is reestablished in the field? It's our responsibility to ensure that we maintain confidence in the penal justice system of Canada. And we thank you for the opportunity to come here to answer your questions and to explain how we conduct prosecutions. And we certainly consider what goes on in the communities where we are and where we conduct prosecutions in order to understand the impacts of the decisions and what goes on in their communities to ensure their safety. I'm glad you're there as well, because we're in our universe of administration and all that, and we focus more on the legislation, the commas and the points and all that. But what I'm saying is that according to our witnesses, there is inequality. They think it makes no sense at all. And I think it's important for you to know that you are a witness, but on the other hand, we're the witness of our witnesses. So please do take note of it, because the witnesses coming here do not seem to agree with the directives that you're mentioning, and they seem to say that there is inequality and political interference. Earlier, you talked about specific regions, but sometimes it can be uneven from one region to the next. According to you, should the laws be applied? You seem to think that depending on the regions, it's a criterion that you can evaluate the regions, the ethnic origin, all that. According to you, and here I'm really talking to you and not on the legislation, should we really make a distinction by region as to how act is enforced that protects our resources and nature? Should we tell one region yes and another region no? We're more relaxed about it. Is that how we do things? So I didn't mean that there's a difference for reasons. For example, if there's a lot of offenses under the Fisheries Act that have an impact on the sustainability. Well, it has an impact on the sustainability of the fisheries, then we can say that it's in the public interest to conduct prosecutions because there's an environmental impact, or elsewhere there might be almost the same impact or less impact because. But don't you find that it's dangerous to start making distinctions in one region? It's dangerous. Shouldn't we have clear, simple, and accurate legislation easy to enforce, according to you? I'm sorry, but the time is wound up. If you could please give a very brief answer. Thank you, Chair. Just to clarify, because I think that the rules are drawn in the abstract here. Our role is really to specifically, in the specific cases with the specific facts that apply, we make a prosecution decision. So it's not the trends or the regions that determine that for us. The issue of regions will be informed by geographic factors, by the nature of the species that's being fished in that region. So there are a number of factors that will influence our decision whether to prosecute, but we're not guided abstractly by trends. Thank you very much, Mr. Hardy.
For 5 minutes.
Thank you very much to the witnesses. We talking about public perception and the fact that there appears to be different rules for different people in different circumstances. Is there any kind of public education going on, and how can we have the public understand how these rules are being enforced?
The Public Prosecution Service, we don't have, say, formal public education. We do in the communities where we live and we work and where we bring prosecutions, have relationships with community stakeholders and a dialogue to ensure that we are understanding of what's going on in those communities, in those jurisdictions. We also, prosecutions are brought forward in the public sphere, and so there's a lot of information that is able to be shared about a prosecution and alleged offense through the prosecution process itself.
Okay, so if the rules change, which obviously sometimes when rules, when we make different policies here, for example, as we're reviewing the Fisheries Act, how does the people out in the field, how do they find out that something has changed?
Mr. Chair, perhaps I can address that. I do not work for this part of the department, but we do have a group that does compliance and promotion. So when there is a new piece of legislation or a regulation or amendments to a regulation, they share information out with the public. They tend to determine who that regulatee group is. It could be a small group of industry that's, for example, running particular types of factories, or it could be much larger and greater percentage of the population, and they will provide information out to the public on those changes.
Okay, and just curious about your thoughts on, are there too many gray areas within what we've just been hearing about where you're available to make decisions based on circumstances? Should the rules be tightened up further than what they are so that there isn't as much discretion available to the people that are enforcing the rules?
I don't think I can pronounce on whether we don't have necessarily opinions on the way the legislation is written, but what we do is when a piece of legislation or regulations are being developed or amended, our officers provide advice and guidance to those developing the regulations and legislation to make sure that they're enforceable. So we are directly involved in that regulatory process when that occurs.
Okay, and to Ms. O'Connor, just relating to international laws, how does Fisheries and the enforcement of the Fisheries Act, what is the collaboration between international laws?
So I'll only be able to speak to how that might impact a prosecution, because it would be for ECCC or the Department of Fisheries to advise about how they may consider that in their enforcement. But when a prosecution comes to the PPSC, pursuant to Canada's laws, that's the jurisdiction that we have to prosecute.
Okay, thank you so much.
Thank you very much, Mr. Clausen. And just looking at the time, we have about 5 minutes. And so to wrap, I just want to give one question to each party, and then that will be all the time that we have. So, Mr. Small, if you have one question you'd like to ask before, just to wrap this up.
Thank you, Mr. Chair. Through you to Ms. O'Connor, is it possible that some decisions that you make in terms of prosecutions could be watering down the intent of the Fisheries Act in terms of conservation? I heard you say that in terms of ethnicity and whatnot, you didn't want certain groups to be overrepresented in prosecutions. But is it possible that there comes a time when the resource becomes at risk and conservation is thrown out in favor of wanting to maintain ratios with certain ethnicities?
Thank you for the question. For the independence of the prosecutorial function, while we, of course, consider a variety of factors that impact communities and public safety and the well-being of Canadian society as a whole, we assess our files individually in accordance with the factors that are published and publicly available in our desk book. And so to the extent that there may be policy concerns and impacts, that is for the honourable members of this committee and our elected officials to determine. And importantly, the prosecutorial service will stay within our prosecutorial lane in making decisions on individual files, once again ensuring that I've communicated to this committee that we do consider a wide variety of factors and impacts on Canadians when we're making our prosecutorial decisions.
Thank you.
Mr. Small, I have a question that I'd like to ask from our side here. And Ms. Rogers, earlier on, near the beginning of this meeting, you mentioned the potential of having administrative monetary penalties, AMPs. And I know it's maybe not your role to give advice on how the Act should be amended as you're involved in enforcing it. But I was hoping you could share with this committee how bringing in such types of penalties would be helpful in ensuring better enforcement and deterrence in some of the Fisheries Act violations and better outcomes on the ground.
Thank you for the question. I can speak from my experience in terms of enforcing the Canadian Environmental Protection Act, where we do have administrative monetary penalties for certain subsections of that Act. It gives us a different tool that does not require us to actually go through the whole court's process. It is not a ticket per se, but it is, from a layperson's perspective, it is somewhat more like a ticket where if there is a low to medium risk infraction, we can provide an administrative monetary penalty that brings the irregularity back into compliance. So it doesn't take the same level of resources it does to work with our colleagues at the PPSC, which we very much appreciate their work. But that's a long and potentially resource-intensive process. It costs a lot of money. It takes a lot of time. An AMP is fairly quick. We still have processes to make sure that we issue AMPs in a consistent and orderly manner, but they would give us a tool that we could use on a more regular basis for the smaller and medium offences. Otherwise, we're generally issuing warning letters for those offences, and it would produce a more efficient and effective ability for us to enforce the laws that we have as we do under CEPA. Again, I'm not suggesting that this is a route that this would be for parliamentarians and for the sort of policy decision makers to decide, but that has been our experience under CEPA. It's given us another tool. We've seen the number of AMPs that we've issued go up over the years as our officers have become familiar with this, and it has certainly made an impact in terms of our enforcement abilities under CEPA. Thank you.
Thank you very much, Ms. Rogers. Et pour terminer, on va à Monsieur Deschênes seulement pour une question.
And conclude, Mr. Deschênes, for one question. Thank you, Chair. I'll be brief. Ms. Connor. One of the possibilities is at the end of this study in the committee, they might propose that the directive be changed because a lot of partners in the fisheries and fisheries officers, and even an Innu from the North Shore, whom I spoke to a few days ago, who is in fisheries, who says that the differentiated approach is perhaps not the best way, or if there are abuses, they would like to see charges laid. So in the case where we propose a change of the directives so that we can make sure that the enforcement is more consistent and that charges are laid and that the indigenous identity criteria is applied differently, do you see any obstacles at the constitutional level?
Just pour clarifier, de nos directives, comme du guide?
In our directives, in the guide, the desk book? Well, it's in the Act. It's only the Attorney General who can give us directives. Yes, but if the committee were to file a report recommending that the directives be changed, would the Minister of Justice send you new directives resulting in indigenous identity be considered differently? Do you see any constitutional obstacles to that? That would be a question for the Department of Justice. I'm not a lawyer with constitutional expertise. Thank you. Thank you very much, Mr. Deschênes.
for today. I do want to thank our witnesses for being here for a full 2 hours to take questions. Your testimony is going to be very helpful as we're finalizing our report on the review of the Fisheries Act and, importantly, its implementation. Our next meeting is going to be on Tuesday, December 4th, where we're going to continue our additional meetings of the review of the Fisheries Act. And with that, I'm adjourning the meeting. Thanks, everybody.